The DIFC in its legislative agenda typically follows two clear paths. We go outside, we benchmark. As a global financial center, we obviously want to be in line with global best practice. So that's one part of why we decided to make some changes. The other part is we do a fair amount of introspection in a working group methodology where we obviously consult with firms and experts like yourself in trying to understand what are the requirements from employers and employees. And typically we also look at the courts and look at the pressure points in terms of where we see most of the disputes are centering around. So that's typically what prompts us to change.
Indeed, and I think on the point that you made, Jack, about there being a balance to be reached, in terms of the family-friendly provisions within the new law, there is a balance, I'd suggest, in the sense of there's now the introduction, of course, of part-time working, of paternity leave, increased rights around adoption, and then also changes to how sick pay is governed, how annual leave is carried forward and the limitations around that. And I suppose some of those are the more headline-grabbing provisions within the new law. Then, of course, from a legal perspective, there are important changes, and we don't have enough time to mention them all, but around discrimination and Article 18, which was the penalty clause under the old law. Be interested just to get your perspective on those changes too, and the rationale behind them.
Well, as you pointed out, Gordon, the issue of this even-handed approach, and if you look at all of those changes, I think in every single one of them, we tried to maintain a balance. We went outside, we know what global best practice is, and we tried to brought that into the DIFC, knowing that it's still part of the UAE, knowing that there's a broader employment market out there, which from a realistic perspective you have to keep in mind. So from that perspective, to balance all of those is actually quite an interesting exercise, and obviously one that you were very much part of. But if you look at every one of those, I think they were either brought in to provide more legal certainty. It was then from a balanced perspective where we thought it should fall in terms of employer rights, employee rights. If you look at the limitation periods, we know that people have their rights and they should be able to pursue those, but at the same time it's unfair to expect of an employer to 6 years after the fact deal with a particular dispute, say on discrimination. On family-friendly rights, I think it's just fair that we've extended it somewhat to fathers. We've extended some of the rights from a prenatal perspective to the expectant fathers, and also in relation to adoption rights that follow the same benefits now. Ultimately, the proof is in the pudding. We've gone out, we've consulted, we've benchmarked, and we've done a fair amount of outreaching, and now it's a question of people considering in this course of the next few couple of months before this law becomes effective, and then see that everything is in order, essentially.
Yeah, and I think the legal certainty point you make is a valid one. There is now, of course, a 6-month limitation period in the law, which does give certainty for employers as to when they can expect to receive a claim from an outgoing employee. And of course, the remedy in discrimination claims and the ability now for employees who are able to successfully make out a discrimination claim to seek various remedies before the court is a step which would seem to align the DIFC with other sophisticated, mature jurisdictions, and also pay credence to the global movements, whether that be Me Too or otherwise. So clearly that was part of the thinking and deliberation on the DIFC's part.
Correct. I think the other thing that we've spent a lot of time on, from a practical perspective and just being pragmatic about how we do business, is actually to whom the law applies. The fact that you now have a clear distinction between employees, people who come here on secondments, people that are short-term employees, people that are part-time employees, and now different entitlements under the law, which once again I think provided a lot of clarity and certainty.
And I suppose you mentioned secondments. I assume, and correct me if I'm wrong, in making the assumption that the part of the driving force for that was large financial institutions who would typically have key personnel coming to the DIFC for 6 months or 1 year, and at the moment obviously those DIFC licensees have to wrestle with dual employment rights in both jurisdictions. So I'm sure that will be a welcome change from that particular section of the business community.
Correct. I mean, ultimately we know that we're at a transition point where, you know, multinationals they come and do business here, and they do so in a multitude of jurisdictions. And in that context, people don't always come as permanent employees. And to have provided clarity on that and flexibility on that, I think was a key objective. Okay, so Gordon, just for the sake of interest, now that we've made all these changes and tried to be as even-handed as possible, how do you see that translating back to the day-to-day life of employers in the centre?
Well, it's fair to say since the announcement we've had a lot of activity from our client contacts and a lot of interaction with them around review of existing employment contracts to make sure there's alignment with the new law, review of template employment contracts to make sure that businesses are aligned going forward, review of employee handbooks, and particularly policies around bullying and harassment, around equal opportunities, around grievance procedures, all of which require to be reviewed in light of the new law, particularly in respect of the remedy for discrimination claims, because now the potential implications of getting it wrong are much more onerous than they once were, whether that be an award of compensation to an employee before the court, whether it be a declaration from the court that there has been a discriminatory act, which could obviously have a ripple effect with parent companies in the US, Europe and beyond. So that is the steps that we're advising our clients to take. There's obviously been other legislative changes recently in terms of the DIFC operating law, which introduced whistleblowing provisions. So again, that forms part of the exercise where policies and procedures are being re-evaluated.
And what was the feedback, just in general, from your clients?
I think that the general feedback is, you know, aside from the fact that people often don't like legislative change, if things are settled, then of course people become used to that settled position. However, I think there was a recognition that the law did require to be changed. I think that generally speaking, the focus of the clients that we've dealt with within the DIFC has been, how do we get ready, how do we get compliant, how do we ensure that we are ready to go in terms of 28th of August when the new law becomes effective.
Good. Well, thanks.
Thank you.